This conference will now be recorded.
Esteemed speakers, members, and friends from the industry, a very good afternoon. Welcome to the web seminar on compliance and regulatory, staying on the right side, organized by the German Engineering Federation VDMA in association with Clasis Law. Before we start, I would like to request all the participants to kindly keep themselves muted and please use the chat box for all the questions. Friends, the German Engineering Federation VDMA is an association of the German machinery and plant manufacturers. With more than 3,300 member companies and over 1 million employees, it is the largest industrial association not only in Germany but in the whole of Europe. We cater to 38 specialized sectors under mechanical engineering. Our members produce machinery worth 232 billion euros and export 78% of it. Having our head office in Frankfurt, we have offices in Brazil, Russia, India, China, Belgium, and Japan. Next slide, please. The office in India is headed by our managing director, Mr. Rajesh Nath, and we have offices in Mumbai, in Bangalore, in Kolkata, and in Delhi. Next slide, please. Friends, in this day and age, it is essential for corporate to conduct their businesses in compliance with the laws of the land. Lack of awareness on a wide range of laws applicable to a business, constant changes in laws, and lack of knowledge regarding proper practices and procedures often leads to inadvertent non-compliances by organizations. Such non-compliances often result in penal consequences, employee disputes, lawsuits, increased costs, reputational risks, etc., and may also impact in future sale and investment transactions proposed to be undertaken by an organization. To have an in-depth and focused discussion on the above context, VDMA India, along with the partner Clasis Law, is organizing this interactive web seminar today to discuss various aspects of compliances by Indian entities and German companies in India under the Companies Act, the Foreign Exchange Management Act, and the employment laws of India. So to talk about the subject, we have with us Mr. Vineet Aneja, Managing Partner and Head of the Corporate Practice Clasis Law, and Mr. Vikram Bhargava, Partner Clasis Law. Welcome to both of you. But before that, I would like to request, next slide, please. I would like to request our Managing Director, Mr. Rajesh Nath, for his kind address. Mr. Nath has more than 29 years of experience working in various industries in Germany and India. He is accorded the Cross of the Order of Merit, highest civilian honor from the German President for promoting Indo-German.
हेलो हाँ कुछ ना फिर करता हूँ.
So thank you, Ajmal, and good afternoon, members and friends from the industry. Hearty welcome to all of you at today's web seminar on a very relevant and pertinent topic of compliance and regulatory, staying on the right side, being organized by the German Engineering Federation, VDMA, along with our reputed partner, Clasis Law. I extend a warm welcome to our speakers today, Mr. Vineet Aneja, Managing Partner and Head of Corporate Practice, Clasis Law, as well as Mr. Vikram Bhargava, Partner, Clasis Law. Friends, post-independence, India experimented with the socialist mixed economy model, with the state retaining control over commanding heights of the economy, heavy industries and utilities. While private sector activity was allowed, the government tried to control it through a web of controls such as licensing and quotas. Such controls were complemented by high tariff walls. Thus, government was not only a producer and regulator of strategic and important goods and services, it also exerted direct control over the output. Outputs of firms, permission for private entry into sectors which were hitherto the monopoly of the government, and liberalization of quotas and tariffs on capital good imports. From 1991 onwards, liberalization of the external sector meant that tariff reduction were extended to almost the entire spectrum of merchandise trade, and conditions for foreign investment were simplified and liberalized. Friends, a robust, overarching regulatory framework is needed for coordinated development of the economy and its constituent sectors. The regulatory reforms should ideally focus on developing a common institutional framework for regulatory bodies, their roles and functions, their relationship with executive and legislature, and their interface with markets and people. India's policy challenge is not merely to catalyze more enterprises into equally to nurture existing enterprises, to enable growth on economic and wealth side, and job creation on the political side. Once the policy fraternity focuses on reforming this, something we see as inevitable, the political returns will be faster and economic returns higher. They are low-hanging fruits of India's political economy. If regulatory infrastructure can be eased to convert 10% of its 63 million enterprises from informal to formal, 100 million new formal jobs can be created. However, the key binding constraint is what we call regulatory cholesterol, a universe of 1,536 laws, 69,233 compliances, and 6,618 filings that businesses face at an aggregate. Adding complexity to this mesh of hurdles is the fact that they change at a rate that's administratively astonishing. There were 322 regulatory changes over the past month, 856 in the last quarter, and almost 4,100 over the past 12 months. The journey from 1991 to 2021 has served India well. In 1990, India was not part of the world's top 10 economies. In 2021, it is the world's 5th largest. It is expected to be the world's 3rd largest economy within this decade, and $10 trillion within a dozen years. Lying under these macro numbers are two distinct but disjointed ideas: expectation and aspirations on one side, and the need to create jobs, taxes, and wealth on the other side. The easy and immediate way to bridge them is by embarking on compliance reforms. The Government of India has been focusing its efforts to reduce compliance burden for its citizens and business activities. With this endeavor, various procedures and requirements are being revisited so that compliances under these laws can be simplified or dispensed with in order to enhance ease of doing business and minimize regulatory compliances. During the pandemic, the union and state governments made several changes to the laws, rules, and regulations that apply to doing business in the country. Our partners today would highlight forms of enterprises in India and give insights into the important aspect of labor laws and the new labor codes. Before handing it back to my colleague Ajmal, I would like to conclude with a quote which is quite significant to the present day scenario. Jerome Powell, chair of the Federal Reserve of the United States, said, "There is certainly a role for regulation, but regulation should always take into account that the impact it has on markets, a balance that must be constantly weighed." So thank you, friends, and we look forward to an engaging and interesting session with Clasis Law. Thank you.
Thank you so much, Mr. Nath, for an important address. and setting the theme of the day, and telling us the importance of compliance and complying with the regulations, and with the changing laws daily, or that we see, how important it becomes to comply and to know about the laws which are pertinent for doing business in India. So for discussing about the topic on compliance and regulations, setting on the right side, so we have with us Mr. Vineet Aneja, Managing Partner, Head of Corporate Practice, Clasis Law. Mr. Aneja is the Managing Partner and has the Corporate Practice at Clasis Law. He has around 25 years of experience in a range of areas, including mergers and acquisition, joint ventures, private equity, corporate advisory. In fact, Mr. Aneja has won numerous recognitions and accolades to his name. Most recently, he was recognized by the Lex Talk World 2021 as one of the top 100 legal falcons, recognized by Forbes India 2020 as one of the top managing partners in India, also recognized by Forbes India 2020 as one of the top individual lawyers in India, and so on and so forth. There's a list of accolades for Mr. Aneja. And on the other side, next slide, please. So we have also with us Mr. Vikram Bhargava. He's the corporate partner in the firm. He has experience in advising clients in diverse industry sectors, including manufacturing, hospitality, media, aviation, medical devices. He specializes in corporate and regulatory laws with emphasis on mergers and acquisition, joint ventures, fund investments, and private equity transactions. In fact, he is also recognized as one among the 15 rising stars in India's legal market for the year 2019 by Asian Legal Business. Welcome both of you. Over to you, Mr. Aneja and Mr. Bhargava. We look forward to your presentation.
Thank you, Ajmal. Good afternoon, everybody. We are here to talk about compliance. Compliance focusing in three particular areas: Companies Act, foreign exchange laws, and employment law. Compliance needs to be considered while we are talking about staying on the right side, because compliance is not just about when you are setting up a business or making an entry into Indian territory, but it's also about staying on the right side, the continued aspect. At the beginning, Ajmal mentioned the fact that yes, that compliance that is the case. And yes, compliance is or inadvertently and really simply not getting the right advice. Compliance is oriented at the top that
The sound is not very clear.
Calculation but compliance is important whether you're doing business or in market setup or tomorrow when you look at it. There are various aspects to consider when you are looking at a entity or structure. Trademark check. What would I sure if you have compliance. The purpose is not really just to talk about what is a compliance, but also share experiences where you see that you can check or it's whether at the time of entering this basic areas which you what is the trademark?
Mr. Aneja, the sound is not clear. Could you just come a little closer to the mic, please, if possible? Yes.
Is it better now?
Yes.
Okay, sorry. So talking about trademark checks, the intent is that today we live in a world where business is not just one country or a particular territory with another. Businesses are spread worldwide. A company in the US may soon be looking at UK, at India. A company in India may be looking at Europe, maybe looking at Australia. It's slightly far-fetched as well, but at times it is always good to do a future planning and to keep a track, especially of your IP in future destinations where you may wish to visit. This is again based on our experience. We've had instances where a company looking at setting up in India When it goes to look at incorporating a company, it's found that there's also already a company engaged in a similar business with using their name. Yes, there are legal remedies involved, but then that has to take the course of either going through the Ministry of Company Affairs or looking at the court of law. So it is.
तर त्यांनी ठेवलाय HR compliance. म्हणजे आयडियली पूर्वीनीच अटेंड करायला पाहिजे, पण आता ते आलंय. प्लीज अटेंड इट, प्लीज नाही अटेंड इट असं लिहिलं तुम्ही.
Yeah, sorry. Then moving on to saying sectoral caps. Sectoral caps, while most of the sectors today in India are under the automatic route with 100% investment, but there are still certain sectors which require prior approval or have underlying guidelines which need to be complied with, even if the investment is allowed under 100% in those sectors. Examples being insurance, retail whether it's single brand or multi-brand. Then registered office checks. Having a registered office is a basic requirement for any company in India. And it may seem
ते अजूनही मिसिंगच आहे, बोल अजूनही इन्व्हॉइस टाकलं नाही.
Please keep
You
your
can
mic
take it over. Invoice preparation.
Sir, please
Because
mute
from
everybody.
his CSS point of view, he might not have.
A request.
He's generally, I mean, these people are not interested.
Request all the
well,
participants
is
to
it
kindly
possible to identify this individual?
please keep yourself muted during the web seminar. Thank you.
Yeah, organizer can mute anybody.
Okay. So talking about registered office checks, it sometimes, I mean, it seems a very small and insignificant point that a check on a registered office. Well, the purpose of highlighting this in this presentation is sometimes the challenges which are faced when presenting a registered office to the registrar of companies for the purposes of incorporation. Earlier the days were that yes, you have an either have a lease agreement or you have an NOC. That really suffices. But the documentation now required to justify that the registered office address is something which you have a right to, and the person allowing you that right has the necessary ownership becomes relevant when filing applications with the Ministry of Company Affairs. So they actually require documentation to the extent of ownership document, a utility bill, as well as a written no objection. Residency check. Residency, many years back with the new Companies Act coming in, there was an introduction with respect to a resident director being there for every Indian company. Resident director is not necessarily a person who is an Indian national, but is a person who has been residing in India for more than 182 days in the previous financial year. That also becomes essential where for international companies which are venturing into India for the first time to have some person on the ground. Neighboring country check. This came in May of 2020, just after the COVID lockdown. And basically the new regulations provided that any investment in India by an individual or a corporation where beneficial interest ultimately goes back to somebody from any neighboring country of India requires prior approval of the government as well as the security clearance. So this check becomes very important. I mean, we have various countries bordering India, and one of the countries, China being a large investor across the world, it becomes essential to check the roots of the company and ultimate parent and holding individuals. Joint ventures. Acquisitions, you own 100%, in all likely. Subsidiaries, you own 100%. Liaison branch offices, project offices is something which you control. But joint ventures are based on trust, are based on two parties getting together to do a common objective and business in India. And there's a difference in how the relationship starts, because at that point of time, nobody can foresee how that relationship will move in the coming years, or whether it's 5 years or 10 years. It becomes important, and many times what happens is that the principals are entering into this business based on trust, And that's why it's based on a short-term trust, not envisaging what long-term protection is required. Ultimately, every joint venture has a life. It may be a 3-year life, it may be a 30-year life. We have examples of both in the Indian market. It is very important to ensure that initially when joint ventures are formed, that whatever the understanding is with respect to the corporate governance, with respect to legal rights, especially in relation to exit, defaults, are adequately captured by way of a shareholders agreement. And not just a shareholders agreement, they're also adequately captured in their article of association. Because many being lawyers, many of the instances which come to our light are where troubles or problems have started between joint venture partners. But when you look at documentation, it's ultimately all based on an understanding, and there is not much written in by way of a shareholders agreement or even the article of association. Accordingly, at that point of time, when you're looking at enforcing your rights, it's all based on then the trust which you had at the time of setting up a joint venture and less of legal rights available. Having a joint venture is not just about getting into a joint venture, making your investment. You may have an investment of 50-50, you may have an investment of 70-30. It is always good to stay in actual control or be apprised of what is going on in your joint venture company in India. So there's a difference. On board having representation on the board. Economic control is one aspect, but economic control can only be enforced by a shareholder with limited rights. A board control is looking after the day-to-day business. So it is important that yes, you do stay connected with your business, you do keep apprised of what is happening in your business, and above all that depending on the percentage that you hold, you do have proper voting rights or even veto rights in the business. Setting up a business, setting up a liaison office, there are 3 categories when we look at branch or representative offices: a liaison office, a branch office, and a project office. A liaison office has every category has certain criteria. A liaison office requires a profit-making track record, will be immediately preceding 3 years, and net worth of not less than $50,000. A branch office has similar requirements, but the net worth is $100,000. And a project office is more about having a project in hand where the entity is coming to execute a certain project. So accordingly, there is also a life of the project office, whereas the liaison office and branch office are more based on the future and how the business progresses. Liaison office approvals are generally granted for 3 years with an extension of another 3 years. Branch offices, once set up, it is up to the entity to decide how long it wishes to operate as a branch office and then either convert or maybe if it wishes to close down, it can close down. There is no limitation. Companies work under, some companies for years and years have operated as branch offices as well. But the main aspect of these 3 categories is understanding that what are your requirements when you are required to set up such offices. So while there is a pre-requirement of having a project in a project office, there is no such pre-requirement for a liaison or a branch office. As long as you have an intention to do business in India and you meet the criteria, you can do business in India. So the challenges which are faced here is that what are the compliances associated with a liaison and a branch office? The basic and foremost compliance is you need to have your appropriate registration in place. Every entity attracts registrations from an employment perspective, which will be taken up in the second half. But for the purpose of setting up an office, there is liaison and branch offices are governed by the Foreign Exchange Management Act. And at times, people tend to consider that that's all what's required. I need to go to RBI, get an approval, and set up my office. For many, it may sound strange that yes, we all know there's a second approval required. But believe me, there are instances, many instances, that we have also come across, and I'm sure there will be other instances that we are not aware of, where companies have set up liaison or branch offices in India pursuant to an RBI approval. The RBI approval already mentions the fact that yes, once you set up an office, please intimate us of your office address. But what is the evidence of setting up an office? What gives you the legal right to indicate that this is your office? That is the registration with the Ministry of Company Affairs, where in addition to the RBI registration, you are required to get a certificate, which is the Establishment of Office in India certificate from the Registrar of Companies. These are the 2 mandatory requirements for setting up a liaison and branch office. it's a very common, it's known to everybody, but at the same time, we have instances where there are companies which are doing this for certificate, and accordingly they didn't happen. You're not doing the compliances which were required. You're not doing your filings with the Ministry of Company Affairs. Time is passed, but at some point of time, you will look at liquidation or winding up. So now you start the process of rectifying your mistakes. And those mistakes now, if you look up here, then it wouldn't be. Yes, it is important to keep a list of what is there for a license office, what is there for a branch office, and the ongoing compliances. Generally, tax is also a consideration when people look at a license office or a branch office. License offices are generally not subject to tax because you're not allowed to have income in the license office. All your expenses are required to be met by the remittances from overseas, and every year you are required to file a statement with the Reserve Bank of India of no income statement. Moving on from the project office, we come to the funding aspect. Funding aspect as well, again, set up a company, make an investment, capital comes in, shares are issued, and you have a company good to go. But there are a lot of underlying aspects which are still missed. Funding is governed by the Foreign Exchange Management Act when funds are coming over from overseas. Now, funds coming in two methods. One is either investment, it's either in capital. Capital could also be by way of equity, by way of investment shares, by way of debentures, depending on convertible, non-convertible, and loans. When you're doing investment, you are either doing a primary subscription or you're doing a secondary purchase. Generally, when you're setting up a new company, there's going to be a subscription where you do the investments, you issue the share, and you file the information. All between and which need,
कैसे तुम कर रहे हो यार? तो सिर्फ 1.25 मिलियन यूरो को दिखाया है पेमेंट.
Yeah, because of the banking system. KYC is a key aspect. KYC is important, and KYC is not about the investor telling the subsidiary on the ground that these are my KYC details. The KYC has to come by way of an NT 199 from one bank to another. The same bank who remitted your subscription money and to the same bank which received the subscription money. These are basic requirements. All these compliances have to be completed in a time-bound manner. 30 days for intimation of money, 30 days for intimation of the FCGTR, and every delay leads to a non-compliance. A delay, it can be a day's delay, or it can be a 30 days delay, or even longer. And when we're looking at complying or rectifying any compliance, then we get into the compounding process with the RBI, which is basically a voluntary process of going to the RBI and saying them, okay, we made a delay or we made a mistake. We want to compound the offense and not wait for a later date when we are issued any show cause notice. The RBI is lenient in those aspects, and at the same time, there is a penalty which is depending on the amounts involved, legal for compounding that offense. So accordingly, it makes these are some basic aspects. You need to do the KYC. You need to carefully ensure that when the money is coming in from overseas to the Indian company or equity, the remittance and the purpose is subscription to equity. If there is no purpose indicated or the purpose is vague, the auditors are likely to classify that as an unsecured loan. Then that leads to another twist as to how your accounting will take place and how are you going to convert that back to in your accounts to equity, which means going back to the RBI. And while you could have taken care of things carefully at the beginning, you're going to spend the next few months trying to rectify the errors which have been made because of, again, maybe inadvertence. Shortfalls also become very important. If you are subscribing to equity, let's say there's 100,000 rupees which has to come in, have to inform your bankers when the remittance is coming from overseas. Please give instructions for remittance or credit of 100,000 rupees to the investee company in India. We all know there are banking charges. So according instructions have to be given that 100,000 rupees have to be credited net of banking charges, net of foreign exchange fluctuations. These are all small aspects, but then these are the things which tend to be missed and again spend time with the regulators trying to rectify it. Loans. Loans in India from overseas are called external commercial borrowings. External commercial borrowings come under the approval route and the automatic route. Yes, when we talk about approval route, it is about whether you are an eligible borrower and whether you have an eligible lender, or do you need to go to the RBI to get an approval to be classified as an eligible borrower. But being under the automatic route still is not an automatic remittance which can be made for a debt coming in from overseas. There is an underlying process involved, which is not really called an approval, but it's a process of getting a loan key registration number from your authorized dealer. In many cases, people consider that, okay, the ECB aspect is under the automatic route, so I can remit and people remit. The remittance of a debt can only take place once you have submitted the relevant document, once the borrower has submitted the relevant documents with his authorized bank and obtained the loan key registration number, because then the remittance has to take place with reference to the loan key registration number. And again, if these aspects are missed, you're again looking at rectification of what should have been done at the time or prior to the remittance. So while we consider it as an automatic route, but please keep in mind that when it comes to ECB, there is an underlying process or approval required to initiate the lending aspect. It's not an RBI process, it's an authorized dealer process. Then there are other aspects in compliances which have to be taken into account. We had in the recent amendments to the Companies Act, we had the introduction of the commencement of business certificate. Commencement of business certificate was earlier not there for private companies, but now it is also required for private companies. Basically, the trigger for applying for and obtaining the commencement of business certificate is that the subscription money as subscribed to under the memorandum should have come in. So which means that you have incorporated the company, you have opened your bank account, you have received the money, and then you apply for the commencement of business certificate, pursuant to which business can commence. So it is very important that not to start business, not to start utilizing the money till you have the commencement of business certificate. Statutory records and registers. Yes, there are a lot of statutory records. You have the option of keeping them either physical or electronic. Electronic registers were allowed in the last round of amendments with the Companies Act, but I think many still prefer to keep it physical. But these records and registers are also important, and again have to be in a timely manner and regularly signed off by a director, as well as taken on record certain registers at the board meeting on an annual basis. Meetings of the board and general meetings. Board meetings for a year, 120 days difference, once every calendar quarter. But with the COVID situation and the pandemic ongoing, there have been various relaxations by the government. The board meetings need to be conducted with a gap of 120 days. They can be conducted by video conferencing. Earlier, there was not the board meeting, the annual board meeting where the financials are to be placed were required to be conducted in a physical manner, but that also has been allowed by video conferencing. But what becomes important in all these meetings is that, yes, they have to be done in a timely manner, but at the same time, the video record, the VCs have to be recorded. Meetings are allowed by way of video conferencing. They are not allowed by way of call, simply by a voice call. They have to be by a video call or physical. Yes, physical is always the option. And they have to be recorded with the recording being maintained for 1 year. And when it comes to annual general meetings, if the annual general meetings are being held by a video conferencing, then you need to have the auditors also present for the meeting. Annual and periodic filings are very important, not only for the company, but also for the directors. It is the director's responsibility, not afterward, just simply because of its fiduciary capacity to ensure that the company is compliant, but it also becomes to an extent of self-interest, because if a company is non-compliant, for example, if they've not done their annual filings, annual return filing for continuously 3 years, the director will get disqualified. Not disqualified with respect to the company which is in default, because he is responsible for that action not having been taken, but he will get disqualified from being a director from all other companies where there are non-compliances. In fact, I think 3 to 4 years back, we had a round of scanning done by the Ministry of Company Affairs, where they identified all defaulting companies and all directors which were in default. they had been suspended for like 3 years or 5 years. Many are now coming out of suspension, I think in October of 21. So compliance has become important, and whether it's filing with respect to the annual returns or filing on a regular basis, your director forms or registered office forms or deposits form, there are various compliances which have been brought in by the Ministry of Company Affairs. The challenges that we look at with respect to when we're looking at an acquisition, due diligence. Due diligence is quite common. It is for years and years, for decades and decades, companies have been doing due diligence of entities which they're acquiring. But we've evolved. We've evolved not just to go beyond, just to focus on the due diligence. We always have legal advisors, financial advisors doing due diligence. What has also become important is the commercial side of due diligence. Now, due diligence is not just important to do from a legal and financial perspective. You should do a due diligence of knowing what you're acquiring, due diligence of your partner, due diligence of the market. Because of, and in fact, because of the COVID onset in April 2020, we saw many transactions fell through because the basic intent of the acquirer sitting overseas is how can we acquire a target which we can't visit on a regular basis and which we can't have access to. That was the reason that why it becomes important to know your partner. And again, the due diligence also helps in relation to your joint venture relationships. That are you getting into a joint venture with the right person? Non-compliances and liabilities or hidden business liabilities as a part of an acquisition, it is important that non-compliances are addressed. Even if they are not addressed, you have to put them in various buckets. There are two buckets when you look at in an acquisition: compliances which should be taken care of prior to an acquisition, and compliances that fine, we can live with that compliance for now, but there are post-closing actions which do need to be taken into account in the event there are non-compliances. The lack of approvals. See, many compliances, if I take a simple example of a company not having, so a particular instance, we have a company which did not get its registration with the Ministry of Company Affairs for a branch office for the last 12 years. That's one non-compliance. But when they start adding up to 12 non-compliances with instances of breach for not doing any filing for those 12 years, adding up all these aspects can lead to a lot of penalties. Simply and not, so if we were to look at non-compliances from an RBI perspective, the general thumb rule which RBI has that the penalty is 3 times the sum involved. Yes, that's not the model that they follow when it comes to compounding fees, but it is always important to know what your compliances are and to know, at least assess them. It's always best to have them addressed, but assessment is very important. Reps and warranties. Reps and warranties is one thing which run into pages, negotiated at length, but ultimately they are good for reliance. But we all know that looking at it from an enforcement perspective, depending on the governing law of your document, are at times difficult to enforce, especially considering the fact that Indian law talks about actual losses and not indirect losses or any consequential damages. People have started looking at rep and warranty insurance, but that is also started in India, but that's still not passing through so smoothly as it would in the international market, because there's a heavy cost to the insurance premium, which any investor or would expect. Indemnities. Indemnities are standard and desired. We again, like reps and warranties, we fight tooth and nail for indemnities. But if you look at it from an actual perspective, what does Indian law provide? What protection does Indian law provide for a contract? Indian law provides protection for that in case of any breach of contract, you are liable to be compensated for your losses. Indemnity is an additional means to enforce that. So yes, while we may spend a lot of time on indemnities, but even in the absence of an indemnity, the law does provide you, the Contract Act does provide you protection. Cultural and employment changes. Employment again is not a simple area, and that's why we have the second part of the presentation, for which I will pass on to my colleague Vikram, who will talk about the employment law and compliances in India. Thank you.
Thank you, Vineet, for the very informative session. So the next part of a webinar deals with labor and employment laws, which is a very important area for every organization which does business in India. So talking about labor laws, I mean, under the Constitution of India, it is a subject under the concurrent list where both the central and the state governments are empowered to legislate. So accordingly, in India, as you would have noticed, you would come across various acts which are made by the center. You would see state acts and also various central acts which are complemented by state legislations and amendments. So while the central enactments would apply to the entire country, the state enactments, their applicability would always depend upon the place where the company has its offices and where the employees are located. So talking about labor laws, I mean, in India, it's a very extensive topic. We have numerous legislations that we have, and they cater to different aspects of labor laws. So just to give you a few examples, so we would have laws relating to occupational health and safety, which would include legislations like Employee Compensation Act, the Factories Act. Then you would have certain laws dealing with conditions of employment. So which would essentially mean your Equal Remuneration Act, your shops and establishment legislations. Then certain legislations would deal with your wages, compensation and benefits, which would talk about the minimum wages, the timing of payment of wages, bonus, gratuity aspects. Similarly, we have women and child labor centric laws, such as the Maternity Benefit and the WASH Act and Child Labor Prohibition Act, and so on and so forth, leading up to certain social security laws like your Employees Provident Fund, Employee State Insurance, and the Labor Welfare Fund, which is predominantly applicable in most of the states in India now. So coming to the need of complying with labor laws, it is important to understand various aspects. Now, there is a general misconception that a wide range of labor compliances are optional and they are good to do things. Let me clarify, the reality is quite the opposite. During this session, we will be discussing a wide range of compliance aspects which are all mandatory and they are not at all optional for a company. So having a compliant organization leads to a lot of advantages. Now, a number of labor law compliances are designed for the benefit of employees. Accordingly, it is generally seen that compliant organizations and its employees would always have a better relationship as compared in the case of organizations which tend to be non-compliant. Needless to mention, compliance would help in avoidance of a lot of cost, as it would avoid fines, penalties, litigations, and even labor disputes. A very important aspect which is important from a compliance perspective, and that it leads to the safety of directors and key employees in a company. Particularly the ones who have been named as the persons responsible in various labor filings and registrations. So there are various non-compliances which may, apart from leading to penalties on the company, may even lead to penalties and imprisonment for the company officials. So it is essential that compliance is maintained on various aspects of labor law. Lastly, as Vineet had also touched upon the fact that non-compliances may also have an impact on any merger or acquisition or an investment deal that an organization is undertaking. Whether it's a financial investment or a strategic investment, no investor would like to invest or purchase a non-compliant company and pick up historical liabilities. So moving on to some of the challenges which are faced by corporates in maintaining labor law compliances, one of the primary reasons is lack of awareness or knowledge of regulations. Now, this predominantly arises from the fact that the quantum of compliance-related actions under labor laws are quite extensive and they are quite complex. Another reason which can be attributed to non-compliances is lack of initiative sometimes to conduct periodical audits, to do health checkups of organizations, on a timely basis. Typically in India, in our experience, what we've seen is that organizations tend to wait for something to go wrong or the authorities to approach them before they move forward with their compliance activities. But generally, as has been the case, at that point of time, it is very difficult to avoid any sort of penalties and penal actions that the authorities may enforce. Now, with respect to the labor legislations, their applicability to a particular entity would depend on a variety of factors. One of them is the number of employees that a particular organization has. So applicability of various labor laws would be linked to certain thresholds that are provided under various acts. For example, your Provident Fund Act would become applicable on an organization once it crosses the threshold of 20 employees. Similarly, for employee state insurance, it would be 10 or 20 depending on the particular state where the company is carrying on its operations. Acts like maternity benefit and gratuity would become applicable on reaching the threshold of 10. Another factor which would determine applicability is the location of the factory or establishment, which would eventually determine what state laws need to be complied with because they are specific to the location of the establishment. We've also seen that a number of labor laws are applicable based on the nature of business that a particular establishment carries out. There are specific laws which deal with aspects like construction workers or mine workers, so they would have their separate legislations, and they are specifically regulated by their own set of regulations. Lastly, there would be the applicability would depend upon the type of establishment. So, for example, in case of commercial establishments, the Shops and Establishments Act is applicable, and in case of manufacturing unit, the Factories Act may be applicable. So these were some of the factors which a company needs to consider to determine what kind of labor laws would be applicable to it. Moving on to the types of labor compliances. So in India, labor compliances are quite extensive and they may be split into various categories. So one of them is that various labor laws would involve obtaining certain registrations and licenses. Some of the important ones being your Provident Fund registration, your state insurance registration, factories registration. You have your Shops and Establishments registration. Now, for ease of doing business, with time, most of these registrations can now be obtained online. However, there are still certain actions before a registration is granted. Another category of compliances are the notices and abstracts that an organization needs to display on their notice boards. Now, this is commonly not followed is what we've seen across organizations. Now, the intent behind these compliances is to make the employees aware of their rights and obligations under the labor laws. Now, this is something that, if there is a labor inspection which happens on an organization, the labor inspector would be quite keen to have a look at your notice board, what kind of information you displayed. They would look for things like the shift timings, working hours, holiday list, constitution of your internal committee under the POSH regulation, and also extracts of various provisions of labor laws. Then another action point, which is practically the most tedious task that every organization needs to do, is to maintain the labor registers under various labor legislations. Now, every organization is required to maintain them, and these labor registers typically would provide information pertaining to aspects such as payroll, salary and components, attendance, leaves, fines, social security benefits, maternity benefits being provided, and they need to be updated periodically depending on the nature of the register. Some need to be done on a monthly basis, some may need to be done on a quarterly basis, or a semi-annual basis, or an annual basis, but these are certain registers that every organization needs to keep. Now, certain states would allow them to be maintained online, while certain states would still require physical maintenance of these registers. Labor laws also provide for submission of certain periodical returns with the concerned authorities. Now, they may be annual, semi-annual, or quarterly returns. Some of the common returns which organizations need to submit would include your annual returns under your Shops and Establishment legislations, your annual return under the POSH Act, your quarterly returns under the employment exchange, an annual return under legislation such as Bonus Act, minimum wages, maternity benefits. So you are looking at a combination of various labor filings that need to be made periodically by every organization that does business in India. The social security laws, such as Provident Fund, Employee State Insurance, Labor Welfare Fund, Professional Tax, they require periodical contributions to be made by the employer every month. So that is something where the authorities keep a tab on. Any sort of non-contributions may tomorrow lead to a labor compliance check on the organization with respect to all of the other types of compliances that we are also talking about. Finally, you would have certain event-based compliances, while the others that I discussed were periodical compliances which every organization needs to undertake. There are certain compliances which are contingent on the happening of certain events, such as at the time of making any retrenchments or downsizing exercises, closure of establishments. If you decide to change the conditions of employment of certain people in the organization, in case there is any change in the registration particulars which were provided initially while obtaining a particular registration, that would trigger certain compliances based on the event which needs to be undertaken at that particular point of time. So over the next few minutes, I would like to take you through some of the compliance heads which in our experience have generally been overlooked by corporates in India because they are not regular compliances, but essentially tend to become very important if a situation arises. Now, the first of them is essentially the misinterpretation of the concept of workman. Now, under labor laws, employees can broadly be classified into two categories, that they can be workmen or they can be non-workmen. Now, out of these, the workmen would enjoy statutory protection, which is more than a non-workman in various instances, such as their termination, changing their terms and conditions of employment. Now, there is a general misconception that workmen are basically akin to factory workers or staff who is at a very low grade of employment in a particular commercial establishment. Now, this understanding leads to ignorance of various compliance actions. Now, in India, this concept of workman, because of its applicability across various labor laws, has been a subject of wide judicial interpretation. Based on the court cases, it is now more or less settled that when you consider whether an employee is a workman or not, his designation is not important. So merely saying that a particular employee is designated in our organization as a manager does not mean that he would fall under the definition of being in a managerial or supervisory capacity under the Industrial Disputes Act. So what is more important is to see the nature of duty that a particular employee performs. Now, the courts in India are typically very employee friendly. Decided cases, most of them would tend to show that unless an employee belongs to a reasonably senior position in the company and only does managerial and supervisory work, only that person can be classified as a non-workman. Most of the workforce and the majority of workforce in every organization in India would fall under the category of being a workman. Now, this misinterpretation, a lot of times while such employees are terminated, treating them as non-workmen, not providing with, not complying with the proper procedures of retrenchment, may tomorrow lead to a lot of complications in the termination process, as well as in the case of changing the terms and conditions of employment. Now, another aspect which is commonly overlooked is to unilaterally change the terms and conditions of employment of people who fall under the definition of workmen. One of such instances was, we saw a lot of corporates during the pandemic period, reducing the salaries and pay scale of various people across their organizations. Now, this is something which requires a procedure to be followed under the Industrial Disputes Act, which is commonly not done. The Industrial Disputes Act in this case would essentially require a 21-day notice to be served to the workmen who are going to be affected by this particular change. A copy of the notice also needs to be sent across to the government authorities. If the workman comes back with a particular dispute on the fact that these terms and conditions should not be changed, then at that point of time, such change is not going to be in compliance with law unless that is resolved by the industrial tribunal. So essentially, if the worker does not say anything for 21 days, only then can his terms and conditions of employment be changed. Next is leave entitlements. Now, it is common for companies, particularly multinational companies, to adopt their internal leave policies, which would essentially follow the leave pattern which is followed in their parent entities, which are in another country. However, any such policy is also required to comply with the local state laws pertaining to leaves, particularly the Shops and Establishment Act for all commercial organizations. Aspects such as categorization of various leaves into privilege leaves, casual leaves, or sickness leaves, or carry forward of leaves, accumulation of leaves, encashment at the time of termination. All these aspects are covered under state legislations and they need to be complied with by an organization. Lately, we've also seen the authorities being very strict when it comes to the filings under the Prevention of Sexual Harassment Act. This is a filing which needs to be done every year. Typically at the beginning of the year by 31st of January, it needs to be made to the district officer of the concerned jurisdiction where the office is located. This is a relatively new requirement. I mean, I wouldn't call it very new, but it's been a few years. But I mean, we have come across a lot of organizations who are still not doing this. And while the enforcement of this was not, very prevalent, say a year back or so, but we've seen a lot of notices being issued by the authorities to all the organizations in a particular area by the district officer to organizations who have not made this particular filing. An important area where corporates also need to be careful is while terminating the employees or going through a downsizing exercise. Now, in case of termination for the workman category, the law essentially prescribes a notice to be also served on the government authorities. Now, depending on the nature of establishment, on the number of employees, such notice may be in the nature of an intimation, or it could also take the form of a prior approval requirement. Now, this is something which is generally overlooked by organizations. They do go through the downsizing exercise, but in case of any dispute being raised, if tomorrow such compliances are not maintained, it could lead to a lot of complications within the entire termination exercise that the organization has taken. Now, additionally, at the time of terminations, it is essential that employees are paid their statutory and contractual dues, which need to be in compliance with law. They need to be calculated properly. Typically, in most of the circumstances, the heads of payments that would arise at the time of terminations would include salary and reimbursement up to the date of termination. Payment in lieu of notice if an employee is being terminated immediately or has not been provided the entire notice period. We talk about bonus if it is applicable as per company policy. The leaves which are unutilized need to be encashed by the organization. Then you would have a retrenchment compensation under the Industrial Disputes Act for the workman category, and you'll have a gratuity component for all employees who've completed more than 5 years of service, whether they are workmen or non-workmen. Now, this gratuity and leave encashment is very often looked at interchangeably because they have a similar formula for their calculation, which also is not the correct picture. I mean, they have to be calculated in a slightly different manner, but essentially they are different payments, and depending on eligibility, these payments have to be made, both these payments have to be made to eligible employees. So as you would all be aware, the government of India has for a while been proposing to consolidate various existing labor laws into 4 labor codes. Now, these essentially are the code on wages, the code on social security, the industrial relations code, the occupational safety, health and working conditions code. Now, all these would essentially subsume various labor laws which are prevailing in the country, and all of them would be consolidated into these four codes. Now, the present situation is the fact that all of these codes have been passed by the Indian Parliament. They've also received the assent of the President. However, again, labor being a subject in the concurrent list, you need state rules before they can be implemented. While the government has been giving certain indicative timelines, most of the states are yet to notify their own state rules. And as of now, while we speak, the next targeted date is sometimes towards the later part of this. But of course, I mean, that is all going to be dependent on how quickly the states can come out with their applicable regulations. Now, as and when these codes are implemented, some of the key changes which need to be considered as having an impact on the organization is that the codes are introducing a uniform definition of the term wages. Now, under the current laws, most of the acts have a different definition of wages, where the components within that particular definition differs from law to law, which results in ambiguity when it comes to calculation of various benefits for the employees. Now, having a uniform definition, what the codes is doing is that they have classified certain components which are to be included in wages, certain which are to be excluded. Now, inclusions would essentially be bareness allowance and retaining allowance. Excluded components would include components like bonus, all the allowances which an organization has. Now, the thumb rule within the labor codes is that you cannot have your basic salary be less than 50% of the gross salary. So if tomorrow an organization, after these codes are implemented, has a basic salary which is less than 50%, the salary structures would need to be restructured. Now, this would also have an impact on your contributions towards the Provident Fund, your payout of the gratuity, because these are also going to be calculated on the uniform definition of wages. Labor laws, they are also being consolidated within these codes. So there will be a lot of unified compliances that will come up. Right now, we have different compliances under different acts. Now there would be common compliances under various codes. And while the formats and forms are going to change, we do not, having carried out an assessment, we do not see too much of a difference in the information that an organization would need to gather to maintain those compliances. There is going to be certain increases in threshold for applicability of certain compliances. The standing orders would now require 300 workers. The definition of workman, which is now going to be called worker under the new wage code, has been increased from 10,000 to 18,000. There is also a proposal to set up a worker reskilling fund, which would essentially require organizations to deposit some amount of money each time they retrench a particular employee within the government fund, and the funds within that the government gets will be used to make certain payments to employees who are retrenched. Additionally, one of the very important things which is also happening is that the quantum of fines and penalties are drastically going to increase under the new labor codes, so which gives further rise to the need to maintain compliance. So thank you for your time on this. I would now leave the floor open to any questions that you may have for me and Vineet.
Yeah, thank you. Thank you very much, Mr. Aneja and Vikram. Thank you for the, I think, excellent presentation. And in fact, I was just looking at the number of attendees. We had almost 95% of the attendees who have stayed with us throughout the duration of this of your presentation, I think, which speaks volumes for the interest that your presentation has generated. So thank you very much. We have a few questions. I would maybe start with Mr. Aneja. Mr. Aneja, this is the question. The person has asked if we have not received any new share capital from NRIs, just have foreign holders and probably debtors, do we need to file FLA, foreign liabilities and assets return?
Yes.
I don't know, is that clear, the question? Yeah.
The SLA to be filed in July is associated with any element of foreign exchange in or investment in the company. So even in the case that, I mean, there's no individual investment, but if there's even debt, so there, wherever there is any foreign element, that SLA has to be filed.
Mr. Aneja, you also mentioned, for example, about these board meetings that can be conducted through video conferencing. This was, I think, one of the changes that the pandemic brought about by the regulation. So, are there any such other changes you would like to briefly mention? Prominent changes?
So the permissibility of having board meetings by video conferencing, in fact, came in the last revision of the 2013 Act. The further changes which came in on account of the pandemic was that even general meetings could be held by video conferencing, and more importantly, that while earlier the accounts, when the board is approving the accounts, that has to be done at a physical meeting. Such meeting was also allowed to be held by video conferencing. So if you look at today's scenario, every board meeting can be held through video conferencing, and general meeting can be held through video conferencing as the amendments stand today.
Vikram, there's an interesting question regarding the labor codes or labor laws. Now, with the new labor codes expected to be implemented, what would be the impact on existing labor law litigations? Also, would penalties be considered as per old law or as per the new law that may be implemented?
So essentially, once the new labor laws do come into effect, I mean, they would have provisions pertaining to the fact that any sort of non-compliances which happened before their implementation would now be taken up as per the new laws, but the penalties would essentially still depend upon the time when the non-compliance was made. So if it is a continuing compliance, then you are still looking at some of the penalties being imposed as per the new labor codes. But if it is a historical matter, then the laws which were prevailing at that point of time should apply.
Okay.
So it's like a similar situation, Mr. Nath, that like when the Companies Act came in 2013, where there is a corporate non-compliance continuing in the 56 Act, which is then continued in 13 Act, penalties are considered based on the prevailing Act at the
Then, Vikram, another question which is more of a general nature, whether implementation of the new labor codes can be termed as true reform or viewed as a consolidation exercise?
Difficult to say. I mean, it's a mix of both. That's typically going to be the answer because, while we would see some ease in compliance related aspects, especially that there are going to be unified compliances. But, even while we carried out an assessment, those unified compliances would essentially require you to do all the things which you were doing in 5 different compliance activities into one. Now, of course, there is going to be, while the government is going to say that, we are consolidating the definition of wages, the far-reaching impacts that that particular provision is going to have on organizations, that is not something that you would expect every employee or every employer to be happy with. Because, one of the consequences of the definition of wages becoming uniform could also be the fact that the employees' in-hand salary may also get reduced in certain organizations because of the increase in their provident fund contributions that would be made now.
In fact, Vikram, there are a couple of questions related to leave. Now, requirement of minimum number of leave as per PL, EL, to be given to employees for an organization? And one more related question is, can employees be forced to take leave, resulting in no or low accumulation of encashable leave?
You cannot force somebody to take a leave. I mean, this is a question which commonly came in during the pandemic lockdown, where a lot of organizations wanted their employees to go on leaves, exhaust their leaves, and thereafter even proceed on unpaid leaves. Now, this is not something which you can force an employee towards doing. It's more of a negotiation aspect that employers need to take up with the employees. A lot of companies do have policies in place where they do recommend the fact that the employees should at the end of the year take a minimum amount of leaves, because I mean they try to camouflage it in a manner that it is essential for productivity and everything. Essentially, I mean the fact is that if a particular employee decides not to take leaves during the entire year, there is nothing an employer can do about that. And at that point of time, if he quits employment, he will have to be paid his unutilized leaves up to the prescribed threshold limit. Or if he has leaves in his balance, he would take that forward to the next year.
So there's one more question. Does signing of employment agreement along with salary component by principal employer in the country of origin have any implications in the operating country, or we can adopt the local structure? Especially, can the statutory component be challenged in case we adopt local structure?
So this is in case of an employee who's being sent to another country to work, who signed an employment contract in India.
Right.
So in that particular case, yes, I mean, in most of the instances, what companies, so this is going to be in the nature of a secondment. And there are a few aspects that need to be seen. Of course, one of the aspects are the local laws of the particular jurisdiction where the person is going, because typical models which are followed across the market is to have an employee of an Indian company go abroad on secondment. All his payments and social security benefits are paid out in India, and that particular person in the foreign country is just paid some minimum allowances which would sustain him in that particular country. But in that particular instance, what is also important to see are the laws of the foreign jurisdiction, because if they have their minimum wage laws where no person can work in that particular country, then those need to be followed. But as far as Indian law is concerned, in cases of secondment, the Indian companies are free to follow Indian law. But that needs to be complemented by the laws of the jurisdiction where the employees are going to be seconded.
So you see, Mr. Nath, it's like a person working in Delhi. If a person goes from Delhi to Mumbai to work, he has to be given the labor benefits or labor entitlements as per Maharashtra, not as per Delhi.
Right. One more general question, maybe, Mr. Aneja, from my side is, over the period of time, we are talking about ease of doing business, easing of certain compliances, regulations. So in your opinion, Mr. Aneja, how has it been? Do you think things have simplified? For example, if we consider the labor codes, now the industry feeling is generally that things are on ground. Reality is not going to be much easier. In fact, some of our members of the German companies feel things will become a little more complex than it was before. Certainly, we have seen a lot of these. There is going to be these new codes, but things may not necessarily be eased out. So I just wanted your opinion, Mr. Aneja. How would you perceive that?
So I think it's a question of adaptation to the changing world. And when you talk about ease of business, what generally happens is there is always a comparative which is put in place on ease of doing business, and that comparative happens one jurisdiction to another. So to give you an example, we had a instance of a client wanting to invest in India by way of debt, and there is a pre-requirement, and the fact was that, okay, in my country this is not required. But then there's a difference in what restrictions your country has, and at the same time, it also becomes relevant as to, from a business perspective, do people want to invest in your country? India doesn't want to operate for foreign investors just from a debt perspective, because if given an option, everybody would look at investing in debt so that there's a secure return. They don't have exposure to equity. But has world changed? Has things changed? I would say yes. Let's go back 2 years, I don't know, maybe 3 years back. When you were setting up a company in India, you first go to the registrar of companies, you incorporate the company. Then you go to the income tax authorities, you get the PAN, you get the TAN. Then you go to the labor authority, then you go to the bank, please open a bank account. Then you go to the labor authorities, give me the registration. Today, you apply for incorporation of a company, and with that incorporation certificate, you not only get your certificate of incorporation, you get your PAN, you get your TAN, you get your bank name, you get your provident fund registration, you get your ESI registration, and if you want, you can also get your GST registration. So yes, things are getting consolidated, but at the same time, it's a large country. There are, like you mentioned, so many laws, so many compliances. People may think that, okay, it's been, what now, 6 years of power, things should change, but 6 years is still a very short time to really put last 75 years into perception or make it comparative to any other jurisdiction. It's a question of patience and adaptation. We don't like change. That's the main aspect. We don't like to change, whether it's us or people who are how you're doing business.
Right. Thank you, Mr. Aneja. I think that's well put. So, although there are some more questions, but I think we would send it out later to you all. And with that, I would like to conclude this session. So, thank you very much, Mr. Aneja. Thank you, Mr. Vikram Bhargava also, and thank you to Clasis Law for partnering with VDMA for this very interesting and relevant web seminar. And I would like to thank all our members. We had a lot of senior people also joining this interaction. So thank you very much to all the participants of this web seminar for joining us, and not only joining us, for staying with us almost at the end. We have still a good number of people who are still logged in to the web seminar. And thank you, Ajmal, and my other colleagues who have helped to put this together. So friends, everyone, stay safe, stay well, and wish you all the very best. And thank you, Clasis Law, for partnering.
Thank you, Ajmal. Thank you for putting this together. Thank you.
Thank you. Thank you so much.
Thank you.
Thank you.